Hi, my name is Rajesh. In this clip, I'm going to share with you more about the interplay between intellectual property law and AI as well as data analytics. As I mentioned before, pure data in its raw element, especially publicly available data, may be the types of data sets over which no intellectual property applies. And yet, those may be the most important aspects based on your business model. But recognize that there are certain types of data sets that are organized in a certain manner. And in that situation, the database itself can be protected in certain jurisdictions. So recognize that data needs to be looked at in terms of IP protection, not just in terms of your local laws context, but internationally or at least regionally. So for companies, the key issue is this. Recognize the need to engage with legal professionals early to get a clear idea as to whether or not data and data sets allow themselves to be protected, and if so, how, and take the necessary steps to protect it if in fact it goes beyond just generic data. Now, in the context of artificial intelligence, many times people focus just purely on algorithms and take the stand that algorithms itself is a particular type of area where intellectual property application is difficult and certainly inconsistent across jurisdictions. One important point to note, though, is that in the real value in intellectual property is not just in the algorithms, but the actual trained models themselves. Meaning many organizations use AI and they build into the AI their own domain knowledge. So there's training, there's machine learning that goes on. Now in that context, when the ultimate final product is a trained engine or trained product, there is potentially the ability to apply Section 7 of our Copyright Act to ensure that that is protected under Singapore Copyright Act. And that's an example of how it is possible to apply intellectual property law over artificial intelligence.